Welcome to the Her Health Podcast, transforming health for women and girls at risk, where we empower women and girls to take charge of their health and well-being. Join us as we shine a spotlight on issues affecting women and girls' health and explore ways to create positive change. Get ready to be inspired and empowered as we discuss health, advocacy, and empowerment for women and girls at risk. Please be advised that this podcast may cover sensitive topics such as gendered violence. We understand that these discussions can be difficult to listen to. If you feel uncomfortable or need support, we encourage you to prioritize your well-being. Consider exploring our other podcasts if these topics are triggering for you. Resources can be found in the description.
Hi, and welcome to the Her Health Podcast. I'm Alexandria Lazochuk, a master's student in the Community Health Sciences specializing in public and population health at the University of Calgary. I also work at the Child Studies Lab, where we focus on research that supports children's lifelong developmental health. Today's episode is adapted from a webinar which is hosted by Dr. Sarah Yercich, where we explore the question, family law protection orders and peace bonds. Do these legal mechanisms ensure the safety of survivors of gender-based violence? Originally aired on April 2nd, 2025 as part of the AVA webinar series, this session presents findings from recent research on the operation of protection orders and peace bonds in British Columbia. Our featured guest is Hannah Ellison from Battered Women's Support Service. In today's episode, she'll unpack common misconceptions about protection orders and peace bonds, the barriers survivors face in accessing and enforcing them, the role of police in the legal system, and the critical importance of ongoing safety planning. Hannah also shares key policy recommendations aimed at improving these legal mechanisms to better ensure the safety, dignity, and autonomy of survivors of gender-based violence. Let's dive in.
Hello, everyone, and welcome to the Alliance Against Violence Adversity, or AVA's webinar series. This is what we're calling Webinar Wednesdays, and we're so grateful that you joined us here today. The focus of today's webinar is family law protection orders and peace bonds. Do these legal mechanisms ensure the safety of survivors of gender-based violence? I'm your host, Dr. Sarah Yercich. With AVA, I'm an early career researcher and lead on the webinar series alongside my amazing colleagues, Andrea and Jason, who are here with us today. I am also the co-director of the Frida Center for Research on Violence Against Women and faculty in the Sociology and Criminology Department at Capilano University. Before we begin, I want to acknowledge that on a national level, Hannah, if you could switch the slide, sorry. That on a national level, we encourage all Canadians and visitors to Canada to learn about the Indigenous peoples of the lands on which they live, work, or visit, and become engaged allies together. We, as Canadians, in the spirit of truth and reconciliation, respect the self-determination of First Nations, Métis, and Inuit peoples, and their rights and responsibilities in culture, language, and the pursuit of wellness. Before we begin, I also just want to remind you of a few procedural things. This webinar is being recorded, which means you can revisit it at any time in the future, and you can also share it as a resource with your colleagues. I'll be monitoring the chat and the Q&A, so if any issues arise, please put them in the chat and I'll happily get back to you. And if any questions for you arise throughout the webinar, please use the Q&A function to pose those, and Hannah and I will have a discussion once she's done with her presentation to kind of go over your questions and the answers she has. Now, it is my pleasure to introduce our speaker, Hannah Ellison. Hannah is a dedicated legal professional with a strong passion for social justice, women's rights, and advocacy. She holds an LLB from Durham University in the United Kingdom and an LLM from the University of British Columbia, where she specialized in human rights and reproductive law in England, Wales, and Canada. Based in Vancouver, Hannah works at the Battered Women's Support Services, providing family and immigration legal support and advocacy for survivors of family violence. And Hannah, as a longtime follower of the amazing work of Battered Women's Support Services, I am incredibly excited for your talk today, and I'll hand it over to you.
Thank you for that introduction. Good morning. I am honoured to be here on behalf of the Battered Women's Support Services today to talk to you a little bit about family law protection orders and peace bonds, hopefully being able to answer the extent to which these mechanisms ensure the safety of survivors of gender-based violence. So I would like to begin by acknowledging the land on which BWSS operates is the traditional, ancestral, and unceded territory of the Musqueam, Squamish, and Tsleil-Waututh nations. We are incredibly grateful to be able to gather, work, and learn on these lands. And a really quick disclaimer that nothing in this presentation is intended to constitute legal advice in any way. So let's get into it. I'll start by looking at some important statistics that highlight the scope of violence against women and hopefully highlight why we conducted this research. So, globally, 1 in 3 women are subject to violence, with intimate partner violence being the most prevalent kind. And in Canada, over 40% of women have experienced IPV in their lifetime. So it's a problem of epidemic proportion. However, we must recognize that some groups of women are at even greater risk than others. IPV reporting is highest amongst women and girls aged 12 to 24, and those in rural communities. Marginalized communities, such as women with disabilities, racialized women, trans and non-binary people, are at greater risk of being subjected to gender-based violence. And despite comprising only 5% of Canada's female population, Indigenous women and girls represented 21% of all victims of gender-related homicides between 2011 and 2021. Clearly, violence against women is a pervasive human rights violation, and it's a major public health concern. So what we need are effective legal protection mechanisms, and we need them to work for all survivors of violence against women. So at BWSS, we know that the period of time immediately before and after fleeing an abusive situation is when survivors of IPV are at the greatest risk of being killed by their partner. At BWSS, we support survivors going through this transition period, and every day we see the need for enforceable methods of protection from violent partners. But we can see from these statistics that the existing measures aren't working, especially not for everyone. So our research, by scrutinizing these methods through the lens of community-based support, we sought to understand first, how these methods of protection are being experienced. Secondly, how we can maximize the efficacy of them as they stand. And thirdly, what policy recommendations can we make that prioritize survivor safety? So, after conducting semi-structured surveys with both community-based support workers and survivors of IPV, we released Justice or Just a Piece of Paper in November 2024. So, before we dive into the lived realities of these orders and how they operate, I will just give a little bit of background information as to what they are, a little bit of legal terminology coming up. So let's take family law protection orders first. Section 183 of BC's Family Law Act allows a court to make an order against one family member for the protection of another family member if family violence is likely to occur. And that is the test. So it's important to note from the outset that the definition of family violence under the FLA is very broad. And regardless of intent, family violence includes physical abuse, sexual abuse, emotional abuse, harassment, intimidation, and unreasonable restrictions on autonomy. And this autonomy is both personal or financial. So under the Act, if the applicant can demonstrate that any of these forms of family violence is likely to occur to them, they may get a protection order. However, as we will see, demonstrating this so that a judge is convinced, it's not an easy feat. And it's particularly difficult where the abuse has not been physical, obviously, because it's much more difficult to prove torment and harassment. So, a few more specifics are the family law protection orders can only be made against a family member. And that includes former or current spouse, and it includes spouses who are often referred to as common law spouses. It also includes a child's legal guardian. So these orders may limit or restrain the communication and or the contact a family member can have with the at-risk person or the applicant. It may also include a term that the family member is not able to attend certain locations, such as school or work. And importantly, these orders can be made on behalf of children if they are also at risk of the violence. So ultimately, the scope of these orders is very broad. A judge can order any conditions that they deem necessary for protection for those at risk. Procedurally, they can be made in provincial or Supreme Court. This is a significant fact because it can be easier for self-represented individuals, and applications can be made without registry fees in provincial court. Additionally, the usual rule that a file cannot be opened in provincial court if there is an existing one in Supreme Court does not apply for protection orders. So there are measures that are intended to make it easier to obtain legally enforceable protection where it's required. We'll see in practice whether they work, but for now, in theory, they are designed to be easier to obtain. And the last thing to note is that breaches of family law protection orders are a criminal offence under Section 127 of the Criminal Code, and they are punishable by fine or imprisonment. So that is family law protection orders. The other kind of protection mechanism that I will be touching on today are peace bonds. So these are orders made under Section 810 of the Criminal Code, and they can be requested by or on behalf of anyone who reasonably fears that another person will cause injury to them, their partner, or their child, or their property. So there is no requirement for peace bonds that the person the order is made against be family. Therefore, peace bonds are the protection mechanism available to those seeking protection against an ex-boyfriend, for example, or somebody they've had a casual relationship with. Now, these orders, the terms will require the individual to keep the peace and be of good behavior for a period of 12 months. It can also include conditions akin to a protection order, in that actions and contact may be restricted. In terms of applying for peace bonds, an individual can seek a peace bond by first approaching the police, who can then ask Crown Counsel to apply for a peace bond. Alternatively, an individual can go directly to a criminal courthouse registry and apply without the police assistance. So the criminal code is explicit that anyone can apply for these orders, and it does not have to be the police. And similar to the protection orders, they are police enforceable anywhere in Canada, and violating one may result in criminal charges. So hopefully that was a bit of a whistle-stop tour of the two types of orders that I'll be assessing today. So in our research about how these orders are experienced, our first key finding was that there is a widespread misunderstanding about them. So our survey indicated that generally, both survivors and workers were more familiar with family law protection orders than with peace bonds. And as is to be expected, workers were overall more familiar with both types than the survivors were. Despite this, the responses from participants indicated that there is a high level of misunderstanding amongst the public. So we identified some common misconceptions that came up a couple of times. Firstly, the enforceability of the orders was not fully understood. Family law protection orders can be enforced by the police. And I was in provincial courts with a survivor, and opposing counsel didn't understand that the survivor had applied for a protection order because of its police enforceability. They accused the survivor of applying for a quasi-parenting arrangement. And it's a concern that we ought to be aware of, but it was certainly not the case. And thankfully, the judge intervened on that day to explain to opposing counsel that what we were here for today was to discuss the enforceability, and that is the key difference. Another misconception was that you needed a lawyer to apply for them. That's not the case. You can be self-represented and apply for these. One more misconception was that peace bonds require a criminal offence to have been charged first. This is not the case. They do not need to have a pending charge. Where an individual is charged with an offence relating to intimate partner violence, conditions of release are often given, and while they do fulfill the purpose of a protective order, it's important to know that one does not precede the other. Peace bonds can be made without that evidential threshold that's required for criminal charges. They are about reasonable feelings of fear. And as mentioned, peace bonds can be obtained without police involvement, which is important for that group of survivors where there is a deep-rooted systemic distrust in police, or where an individual fears police involvement, which is a common factor where the applicant is without status in Canada. However, because individuals are often less familiar with Crown Counsel than police, it's important that support workers know these options, because all survivors of intimate partner violence need to be able to make their own fully informed decisions. Many workers who responded to our survey did not understand the legal test for obtaining the orders. And that distinction between reasonable grounds for fear that's required for a peace bond versus the requirement that family violence is likely to occur for protection order was not reflected. An understanding of that distinction wasn't seen. Because this distinction means that in practice, it's often more difficult to obtain a family law protection order, given the amount of evidence required to indicate on the balance of probabilities that violence is likely. So that was our first key finding, misinformation. Our second key finding was that there was generally a reluctance among survivors to even apply for protective orders. Responses from survivors and workers suggest that we can group the reasons for this reluctance into three broad categories. The first one was a lack of understanding about the application process. The second reason is continued fear of their abuser. And the last reason for reluctance was a lack of faith in enforcement. What kept coming up again in survivor responses was that, why would I bother applying, because I don't think the order can actually do anything for me if it's granted. So, arguably, the law has made attempts to mitigate that second category, the fear, trying to mitigate it as an obstacle to accessing enforceable safety measures. So, for example, an application for family law protection order can be made without notice. This means that an applicant can fill in the form, they can take it to the registry, and they can see the judge the same day, provided availability, but every time I've been, it's kind of same day thing. So from here, if the judge agrees that violence is likely, the order can be made ex parte, which means the abuser wasn't told about the application being made, and the order was subsequently granted without them. As you can see from the little clip from the slide there, that's taken from the application form. It asks the applicant to detail why it's urgent and what you think will happen if the other party is given the opportunity to be at court. So this is a positive measure that if survivors and community-based workers had knowledge of, then it may have allowed these survivors to make fully informed decisions about their options for safety and not be scared to apply because they didn't know they could do it ex parte. Now, it's not a perfect system, and whilst this is a positive measure, what we do see sometimes is, and this is from my own experience as well with a survivor, a judge can provide an interim ex parte order to expire on a date when the other party, the abuser, can present their own case in court. So this approach enforces the idea that ex parte orders are not the norm, and they're an exception when it's urgent. However, this prioritization is being made at the expense of a survivor's mental health, because a survivor is granted enforceable protection, but only for 2 weeks, for example, until she must face her abuser in court. And at this point, he can then attempt to take down all of her reasons for fearing family violence. So this approach is undoubtedly re-traumatizing survivors, and it's dangerous practice. If a court has made an order, they must have been convinced that at one point on the balance of probabilities, family violence is likely to occur. So what is the court's justification for this? Do they think that the likeliness of family violence will have subsided in 2 weeks? Or are they more likely unjustifiably re-traumatizing survivors of family violence? Because when that other party is in provincial court with them, the abuser has the opportunity to cross-examine the survivor. So, one survivor responded the following. In the past, I have always been afraid. I was made to feel like I was in more danger if I spoke up. Speaking up never helped. Even after getting a protection order in the family law case, we are fearful that he will continue to target us now that the order has expired before we could renew it. So here's another identified foundation for fear, and that's the situation when protective orders end. The case law on family law protection orders is quite messy. Every decision is very fact-specific, as is the case in family court in general. However, there are 2 identifiable factors worth noting here. The first is that the duration of these orders do not regularly exceed 1 year. And in our research, survivors who had these orders were asked how long their order was made for, and the most popular responses were 6 months and 12 months. That's the first one. Duration does not regularly exceed 1 year. Secondly, when considering whether to grant an order, the court will consider how recent the evidence is. So if we take these 2 factors in combination, we are in a difficult situation when orders end. So when an order ends, we see survivors no longer feeling safe. They no longer have that police enforceable order that can restrict their abuser from contacting them. However, an application for a renewal or another order may be unsuccessful because there's no recent evidence of abuse. But that's because the order's worked throughout its duration. So does this lack of recent evidence mean that violence is no longer likely? Has the risk completely gone? The well-researched cycle of violence suggests no. But as support workers, we find ourselves having difficult conversations with survivors. So for example, a survivor has endured a marriage characterized by constant harassment. Her husband emotionally tormented her and threatened her, and she regularly had suicidal thoughts. One day, following a particularly violent threat, she called the crisis line, and she fled to a transition house. She managed to obtain a protection order. Her husband was supervised removing his belongings from the home, and she was able to go back. Her husband could not go to her home. He could not go to her place of work. He could not contact her, and this order lasted for 1 year. During this year, the order worked. It did what it was supposed to, and she accessed counseling, gained independence, and began healing. Now a year has passed and the order is about to expire, and she's scared again. Because if she can't demonstrate that violence is likely because she doesn't have recent evidence, it seems that we then have to tell her that she must wait until violence begins again before she can apply for an order. And when the order expires and the harassment does return, the survivor's healing process has already hit a roadblock. Her mental health begins to suffer because, let's face it, 1 year is not that long to expect recovery from a lengthy abusive marriage. And so the harm has happened again because she was in this difficult period of time, being not able to produce recent evidence to get a renewal and having to wait until it happened again to get a new order. So it's not a perfect system, but these flaws may indicate the need for further research. For example, should we be pushing for protective orders for longer than 1 year? And this isn't a conclusion to be landed at brashly because protection orders, they do restrict individual liberty. But we're hoping to highlight these flaws and maybe fuel some arguments for reform, which we'll come to at the end. Now, our third key finding was about enforcement. Ultimately, the effectiveness of protective mechanisms depends upon their enforceability. The police. However, the results of our survey indicate that skepticism on the efficacy of protective mechanisms is not without cause, because when a protective order is breached, survivors are instructed to contact the police immediately. However, participants to our survey reported an overwhelmingly negative experience with the police. So, firstly, there is a reluctance to report the breaches due to the systemic distrust of police. Particularly for survivors of colour and Indigenous survivors, there is a long and well-documented history of being dismissed, not believed, and underprotected by police forces. So these systemic failings have caused a deep-rooted mistrust. And unless survivors see a positive change in the enforcement of these orders, they won't be fit for purpose because the enforcement will remain ineffectual. The second aspect of negative experiences with the police was that, really disappointingly, when survivors do report these breaches, we receive mixed responses from survivors. The majority of responses were negative ones. Police either did not respond or they responded in a manner that can't be considered trauma-informed. A rare few participants did report a positive experience, so we can't make any sweeping statements, and they reported that their concerns were listened to and breaches were taken seriously. But a uniform approach was not present. And it seems obvious that police approaches ought to indicate a uniform condemnation of violence against women. However, it seems that somebody needs to tell the police about the legislative intent of these mechanisms, and that is particularly the case for family law protection orders. The participants to our survey suggested police attitude towards protective orders can be characterized as indifference. And it seems that within the police, there still appears to be what happens at home behind closed doors is private, it's family business kind of attitude. But this isn't the case. We know that the home is where women are most likely to be abused and discriminated against. It's not a private sphere where the state doesn't belong anymore. All people need protection from violence, and when this happens at home, it's more often women being harmed. So if the state is only protecting the public sphere and not the private, the family unit, the state is not protecting women. And we can see from figure 13 on the slide that survivors' feelings of safety were not increasing. So, our final part of the report considered some recommendations and reform suggestions. And number one, probably obviously, is some kind of attitude change on policing policy updates. So, police enforcement of orders, whether an officer will respond to a report of a breach, should not be luck of the draw. And it shouldn't be a matter of whether you were just lucky or you were in an area where the police take these seriously. Police need to know that family violence is not just physical, and that when a protection order is in place, a judge has already deemed that family violence is likely to happen. So they must respond quickly when somebody calls to report a breach. There's no longer any need in this scenario for an individual officer to be making judgment calls. And that we see police not responding at all to these breaches is unacceptable. Inconsistent enforcement is undermining the value of these orders. And it's making a mockery of a system designed to protect the vulnerable. New visible policing policies, for which there are consequences for not implementing, they may go some way in reassuring the public and minimize some of the distrust survivors have. For example, a survivor recently told me that the police advised her, and this is a quote, "No bruises, no restraining order." Firstly, restraining order is not a term used. And secondly, that is just simply incorrect. Police are unfamiliar with the meaning of family violence. And we're not asking the police to go and read the entire Family Law Act. We just wonder if they can simply familiarize themselves with the broad scope of family violence, so that it's not just physical. And this is because they are the enforcement mechanism for orders designed to protect individuals from it. Our second recommendation concerns the length of these orders. So courts are reluctant to make these orders for the duration of which they may be necessary. Following the norm that the orders are usually just 1 year in length has caused a rigidity in the legal system. Research shows that it is the first 2 years after separation that are the most dangerous for survivors of intimate partner violence. This period is marked by heightened risks, escalated harassment, and potentially lethal violence. Separation often triggers feelings of loss of control for abusers. So the evidence is there to at least raise the question, should we be making 2-year-long protection orders, maybe in certain limited circumstances? It would certainly eliminate some of the re-traumatization that's experienced by going back to court and seeking extensions of orders and having to relive the trauma that you've spent possibly a year or 6 months trying to overcome. Okay, the next one. And as I mentioned earlier, the application of without notice and ex parte orders is problematic when it's being granted for just 2 weeks. Because as discussed, the other party can then come to court themselves. Not only does this open the door for an abuser to locate the survivor, because what if they're at a transition house and then they come to court and then their abuser follows them back? It also allows for traumatic cross-examination, as mentioned. And it's dangerous. Part of this recommendation may be mandatory training for all judges in BC, including provincial court judges. What needs to be eradicated from family court are the incorrect stereotypes regarding family violence. And this can only be done where judges are attuned to them, so they can call them out when a party or their lawyer attempts to rely on one. For example, I recently saw opposing counsel submissions for the removal of a protection order. And a big part of their argument was that the survivor had never met the grounds for an order in the first place, because if it was true that she'd experienced family violence, then she would have reported it to the police. So their argument was that his client could not possibly have perpetrated family violence towards his wife in front of his children because she had never called the police. Nowhere in the legislation for protection orders, as it was in this case, or peace bonds, is reporting to the police a prerequisite to a protective order. Neither is it determinative that family violence is not likely to occur. So these myths and these stereotypes about family violence, they need to be removed, and there need to be consequences, and that for somebody who attempts to rely on one. Our next recommendation was that British Columbia needs to adopt and implement Clare's Law. Now, Clare's Law is a policy that originated in England and Wales, and it is formally known as the Domestic Violence Disclosure Scheme. Through this, the police can disclose information to a victim or potential victim of domestic abuse about their partner or ex-partner's previous abusive or violent offending. In Canada, several provinces have adopted similar policies, thereby authorizing police to disclose certain risk-related information to a current or former partner where that information could assist the individual in making informed decisions about their safety and their relationships. BC is not one of these provinces, and it's our position that they must implement this policy. And we would ask that it includes the ability for individuals to know if a partner has previously had either a protection order or a peace bond against them. Now, tackling the misinformation is arguably the easiest problem we can solve, or the quickest. And its impact on survivor safety, this misinformation, can be mitigated by the creation and distribution of user-friendly guides for obtaining protection orders, in particular for self-represented survivors of family violence. And this would be complemented by the implementation of training for our other group of participants, the community-based support workers, because the degree of misinformation in their responses, albeit less than survivors, it still deserves addressing. How are we doing for time? Okay. So, returning to our initial question, to what extent do the protection orders and peace bonds ensure the safety of survivors of gender-based violence? One thing that I have hopefully made clear is that there are a lot of actors at play in the system. There's a lot of moving parts because we've got community-based support workers, lawyers, Crown Counsel, judges, and police. And these arms of the system are very disjointed. There needs to be better collaboration between them. For example, all of these actors need to be operating with the same level of understanding. And the basic one is that family violence is more than just physical abuse. So we can see, therefore, that education remains crucial. And until this misinformation and stereotypes are eradicated and attitudes within the police change, the ability of these orders to ensure safety will continue to be limited. Now, they could be an important safety tool, but the system as it currently operates means that they will continue falling short for a lot of women. Something at BWSS that we are big advocates for is safety planning. So the gaps in the system as it stands can be somewhat closed by effective safety planning. And this means creating a plan for an individual, for her family, for her specific situation that complements an order that may be granted, but that recognizes its limitations. Because in that situation, a survivor can maximize the power of protection orders as they currently stand. They are just a piece of paper, but they are a piece of paper with legal consequences. They have the power to be more than they are at the moment, and improving their efficacy starts with education. Thank you.
Wonderful, Hannah. Thank you so much for your presentation. I love the work of Battered Women's Support Services. I think the Justice Center is fantastic. And when reports like this come out, I know provincially for BC, it means a lot for us. And I imagine this will be important across the country as we start to really have these important conversations.
Thanks for joining us on the Her Health podcast, transforming health for women and girls at risk. Remember, your health matters, and together we can make a difference. Until next time, remember to prioritize your health and well-being. For more resources and support on issues affecting girls, women, and gender-diverse people, visit our website at avatraining.ca. This is Dr. Nicole Letourneau. Thank you for listening.